Contractors' arrangements to pay contingent fees for soliciting or obtaining government contracts have long been considered contrary to public policy because such arrangements may lead to attempted or actual exercise of improper influence. Congress affirmed this public policy but did permit certain exceptions. In general, federal law requires in every negotiated contract a warranty by the contractor against contingent fees, but federal law does permit, as an exception to this warranty, contingent fee arrangements between contractors and bona fide employees or bona fide agencies, and these statutes provide that for breach or violation of the warranty by the contractor, the government may annul the contract without liability or deduct the contract price or consideration or otherwise recover the full amount of the contingent fee. Government personnel who suspect or have evidence of attempted or actual exercise of improper influence, misrepresentation of a contingent fee arrangement, or other violation of the covenant against contingent fees shall report the matter promptly to the contracting officer or appropriate higher authority in accordance with agency procedures. Where there is specific evidence or other reasonable basis to suspect one or more violations, the Chief Contracting Officer shall review the facts and, if appropriate, take or direct one or more of the following or other actions. If the situation is before award, reject the bid or proposal. If the situation is after award, enforce the government's right to annul the contract or to recover the fee, and/or initiate suspension or debarment, and/or refer suspected, fraudulent, or criminal matters to the Department of Justice as prescribed in agency regulations. In the matter of Kola Nut Travel, Incorporated, the protester alleged that there was a prohibited contingency fee arrangement. The GAO noted that it has held that the prohibition applies only to situations where an agent agrees to solicit or obtain a contract from a procuring agency. The fact that an agent's fee is contingent upon the contractor's successful performance of the contract, or even upon receiving the contract award, is not sufficient by itself to bring a fee agreement under the contingent fee prohibition. Rather, the regulation contemplates a specific demonstration that an agent is retained for the express purpose of contacting government officials where such contact poses a threat of the exertion of improper influence to obtain government contracts. In this case, it was determined that the consultant's fee agreement was calculated as a portion of the profit resulting from the awardee's performance of the contract, not in exchange for the awardee's receipt of contract awards. In addition, the GAO noted that the record was devoid of any evidence that the challenged awards reflect any improper influence on government officials. To the contrary, the GAO determined that the agency selected proposals that offered significantly lower prices and were evaluated equal to or higher than the protester's proposal with regard to the non-price evaluation factors. Based on the record submitted, the GAO determined that the protester's assertion that the contracts incorporated a prohibited contingency fee arrangement were without merit.